Hi, my name is Cameron Weir, and I'm here as part of the Vethen Law Firm's video educational series. And today I'll be talking to you about how injunctions can be used in partnership disputes.
Now, one of the mistakes we've seen a lot of attorneys make is they've gone in and tried to seek an injunction when they're pleading that a certain dollar amount may fix the problem. And the whole reason you have an injunctive proceeding is that you're telling the judge, dollars won't fix this. Fair statement? Fair statement. Okay. And in an injunction proceeding, there's almost like two lawsuits in one. One is to stop the person, and that's called equitable relief. And then you may have an underlying claim for money damages on other matters, which is the legal relief that most people are familiar with in a lawsuit. Cameron, why do you have the underlying legal claim, the typical claims that people see on TV as to a breach of contract or whatever, along with an equitable claim for injunction?
Well, one of the requirements for receiving an injunction order from a court is that you show that you have a probable right of recovery. And in that sense, you have to show that you would win the underlying lawsuit where you were asking for money damages.
So, Joe, once we've filed a document with the court, we've established that there is a probable right to recovery. We've got our temporary restraining order, and now we've got the expedited discovery to go before the court for a temporary injunction. There are certain differences between obtaining injunctive relief in federal court versus state court. What are some of the differences that we should keep in mind?
Well, generally in state court, you've got to show that you've pled a cause of action, that you have a probable right to relief, that there will be irreparable injury, and that there's no adequate remedy at law. In federal court, it works a little different. You still got to show a probable right of recovery and a probable irreparable harm if the injunction doesn't issue. But then there's a couple balancing tests that the federal courts throw in there. First of all, you've got to show that the injunctive relief, the damage to the plaintiff, the person asking for the injunction, is going to be greater than the damages caused to the defendant by enjoining them from doing something. And second, you've got to show that issuing the injunction is not going to disserve the public interest.
All right, so in federal court, and some of the federal matters that we would typically see are matters dealing with patents, with trademarks, and with copyrights. Those are pretty much in federal court.
True, and now trade secrets too, under the new Defend Trade Secrets Act.
Okay, and so these matters would be in federal court, so you have this balancing test. How about in state court? Do state judges look at the balancing test and take a look, Cameron, at the harm done to the defendant versus the order that the plaintiff requests?
It is not one of the elements required, but whenever you're getting an injunction, there is a bond requirement. And the purpose of the bond is to be able to compensate the defendant if the injunction was issued improperly. So in looking at what kind of harm will be done to the defendant if it was an improper injunction, the judge will be deciding what amount would compensate them for that when they set the bond amount.
And you've got to be careful on what you request in an injunction. I mean, to give you an example, if you have a claim against an airline, you don't want to obtain and get an injunction preventing a 747 from taking off, because the bond requirement on that may be for the cost of the 747, which would make it prohibitive for most people. How is the bond set, Joe? How does a court decide what an appropriate amount is for that bond?
Well, a court will look at a number of different factors. It could, for example, look at the value of the property. It could measure the bond against the loss of profits that might be generated as a result of the injunction if it's wrongfully issued. Sometimes, if that's not a critical issue, it may set a lower bond or a minimum bond. But there are different factors, as I said, that the court looks at.
One of the issues we spoke about before that's very important in the order is even if the parties agree to the injunction, in other words, the other side comes in and said, okay, we can live with that. Do you have to have any special language in the order even if it is agreed?
You have to very strictly follow the rules of civil procedure for getting an injunction, and the court has to state in there certain things, including that it finds that irreparable harm will issue. If the injunction does not issue, it has to include a finding as to what conduct the defendant is doing that requires an injunction. Finally, it has to very specifically describe what the defendant is enjoined or prohibited from doing, and it has to do that within the order. It can't refer to some sort of outside document.
Okay, so I think the takeaway from that is if you do get the injunction, be very careful for what you ask for and make sure the order is narrowly tailored to what you want.
Absolutely.
Right. And because, look, at the end of the day, unlike most trials, as soon as that temporary injunction order on federal court, the preliminary injunction is granted, the other side can take it up on appeal.
That's correct. You've got interlocutory appeals, both at the state and federal levels.
If you have more questions about injunctions or you're in one of these types of lawsuits, whether that involves partnership disputes, intellectual property issues, or with a non-compete, call us. Go on our website at bethellaw.com, and we'll talk to you soon.